Welcome to Cross-Continent Law. Today we're talking contract law. But as an overview, I just want to say that on this side we're going to be talking law. We're going to be trying to instruct on law, especially undergraduate law, at least for the time being. So my overview also includes this fact that we're going to be talking, our discussions will not be based solely on common law, even though I, the host of this platform, is a trained common law lawyer. So, but I'm just going to say that the reason why we call it cross-continent law is because we're going to be speaking, as it were, from both sides of the mouth. That is, one side of the mouth is common law, the other side is civilian law. But we're doing that because we know that both major legal systems, which constitute the major legal system of a predominant section of jurisdictions across the world, both of them originate from Roman law. So, and both share characteristics that you find in Roman law, from the Roman Praetor then to the Justinian law. Okay, so we are now going to go into contract law immediately. We have no time. So we're going to start with definition of law of contract. How will we define law of contract, a contract in law? We will say that the layman in the streets, the pedestrian you find on the road, if you ask them what is a contract, they'll probably tell you it's an agreement between two people, two parties. Now, will that be sufficient in law? That's insufficient. I might even add grossly insufficient. The reason is that if it's just a contract, an agreement between two people, then it means that agreement between a mom and a dad has to be enforced. An agreement between a dad and his daughter has to be enforced. An agreement between a mommy and her son must be enforced. But these are not the kind of agreements that the courts of law enforce. So we're looking for a better definition. That definition will pull from both the civilian legal systems and the common legal system. So under common law, a contract is an agreement between two persons with the expectation that each of them will be legally bound by the agreement. I'm going to support that simply by quoting to you the American Law Institute definition of it, the functional definition, section 1 of that ALI restatement of 1982. It says that a contract is a promise or sets of promises for the breach of which the law gives a remedy, or for the performance of which the law recognizes a duty. What it means simply is that, broken down, that a contract in law is a set of promises or a promise. It could be one promise or two or three or five or several promises that the law recognizes. And who are the custodians of the law? The courts. Is a set of promises or an agreement which the law recognizes that a breach of it will constitute an actionable offense. In other words, the other party can go to court and ask for damages because you did not keep to your contract, or a performance of which the law recognizes as a duty. In other words, if they come to court, if there's still time to perform it, the court will say you must perform this duty because it's a contract and you have signed it, you agreed to it, so we must enforce it. Therefore, it follows from what I was saying just earlier that a contract between a social contract, or if you like, a contract, a family-related contract, is probably not enforceable. In other words, if I tell my daughter or my son, I'm going to buy you shoes next month, and I don't buy it, it's highly unlikely my son will go to court to sue me to enforce that contract, or will get damages from me if I refuse to buy him shoes. So that's what we're saying. We're talking about promises or agreements that a court of law will enforce. That is the definition of a contract. So, and of course, the agreement, the meaning of agreement means that nobody was forced into that contract. It means that I agreed, you agreed, and so we came into it. So we're going to look at some very important ingredients of a contract.